Hey guys. So Marine Wade or Marine Flag, as is her name here really. She has replied to Taylor Swift's opposition. Um, that opposition was kind of unnecessarily personal and offensive, in my opinion. I think there was jabs made that really didn't need to be made. And there was a lot of attempting to belittle Marine Wade's career, which I thought was quite unfair and gave me a I don't know, a bit of insight, I guess, into how, you know, um, people who are, you know, not of a sufficient stature appear to Taylor Swift. Much like, we saw with how she came across and spoke about Justin Baldoni. I didn't like it, but there were some interesting points made about, some stuff like using hashtags and trying to link herself to Taylor Swift when the album came out, and I wanted to see how that was going to be responded to, and we have it here. It's not that long, so as is always the case with replies. So let's just go straight to. Okay, so introduction. Defendants argue against themselves. Okay. I'm already peaked now. My interest is already peaked in this. They reach for Rogers, but their conduct rules it out. They tout their scale, but their scale is the problem. This is really good. They say plaintiff's claim is meritless and that she should have brought it sooner, and they have been here before on the other side. When UMG was the plaintiff in another trademark case, it argued that side-by-side comparison is the wrong test, that loss of brand control is irreparable harm, and that a defendant who proceeds full speed ahead after notice of infringement acts in bad faith. They now claim the opposite. Defendants are quick to enforce trademark law against others. They just will not apply it to themselves. I think that's very fair. And I am here for this, like calling out the hypocrisy. That was a great opener. Rogers does not apply. The dispositive question under Jack Daniels is not whether a mark has expressive content. Most marks do. It is whether the mark functions as a designation of source. Defendant's conduct speaks for itself. They filed a trademark application asserting source identifying use. They repeatedly register album titles as trademarks and sue to enforce them, and their own opposition describes their global marketing and branding campaign. A branding campaign is textbook source identifying activity. Defendants' authorities do not save them. In neither 20th Century Fox nor Lost did the defendant file a trademark application, maintain a litigation history of enforcing album titles as marks, or describe its own program as a branding campaign. Neither defendant faced a USPTO refusal of its trademark application as confusingly similar to a senior incontestable mark. The central fact here. Defendant's citation to toy trackers is a straw man. Plaintiff does not argue that an application confers rights. She argues it is an admission of source identifying use. Betty's foundation is also inapposite. It predates Jack Daniels and Punch Bowl, did not analyze whether an application is evidence of trademark use, and addressed the unrelated question of premature cancellation. Rogers does not apply. Okay, so this is a bit I was really interested in, the unclean hands. Defendants have not shown unclean hands. Defendants mischaracterize the facts. Plaintiff is an active performer and comedian whose creative identity has centered on the same premise since 2014. the gap between the glamorous fantasy of showgirl life and its unglamorous reality. She has presented that premise in Las Vegas weekly columns on stage and on camera. As defendants' own exhibits show, a typical installment presents plaintiff in showgirl attire, doing something unglamorous, struggling to fit into a car in a large headdress, taking out the trash and picking up after the dog. When defendants released an album presenting showgirls as glamorous, plaintiff's long-standing premise acquired a prominent new foil. She responded to the glamorous archetype the way she always has, by making comedy about it. She posted videos online but offered no goods or services through them, made no sales, claimed no affiliation, and did not pass off her brand as defendants or theirs as hers. She referenced Swift and her album because humorous commentary requires reference to what it comments on. Congress has protected exactly this type of engagement. Plaintiff used hashtags referencing Swift alongside hashtag Red Bull, hashtag Backstreet Boys, and hashtag corporate humor. She used her own audio and drew from Swift, Meghan Trainor, and Billy Joel. That's how social media works. And defendants know it. Their posts do the same. And there's some exhibits of Taylor Swift's account using using audio by Glorilla and Shamilia. And that's how I thought as well, because when I put up a post on TikTok or Instagram, like, it kind of, invites me to attach an audio track to it, and then I can pick through what's available. Taylor Swift was kind of framing this in her opposition as, you used my stuff without permission and we're going to sue you for it. I didn't think that was the case, because am I using someone's work without their permission? I think that's ridiculous. Why is Instagram or TikTok offering, or they even recommend tracks to use with it? So I didn't understand that, but I was waiting for kind of a little bit more clarification on that. But I think to be sort of threatening a lawsuit over your tracks being, recommended or offered by TikTok and Instagram, to try and sue one person over that, as opposed to the social media company itself, is a little bit, I don't know, it seems like an attempt to wield power unnecessarily on the little person. And I also wanted to see like how Maren Wade kind of uses, because when she because the other thing was, they were complaining that Maren Wade had used this green background which was identical to Taylor Swift's, and she'd never used it before. But when I went through the the image that Taylor Swift herself actually put in as a before picture, it did actually have the mint green. It just looks like it's been, things have been reassembled, as it often does. Like, you rotate things and change out the colors, and you have your basic colors that you use a lot, and then you just rotate them. My own thumbnails do that. My own thumbnails, for these videos, is, the design is pretty much standard, and I use that, and keep it like that because I like that. And I change the title, the text that's in it, to go with whatever the video is about. I change the image to reflect who the video may be about, but the color that goes across, like, the one half of the thumbnail, there are like 4 colors in particular that I have, that I am kind of, I rotate, and that's how this works. A lot of people do that. I mean, those colors aren't, in my case, they're not particularly a part of a brand as such. They may be. I'm looking at changing my logo and everything, but for Maren Wade, those colors may have been part of the brand, and she's just kind of rotating them around. And I want to see how she responds to that, because I thought that was just such a stupid argument, so frivolous, to the point where it was almost controlling. It wasn't even the same green, actually. Okay. So we continue. Plaintiff also participated online as a fan. Exactly how defendants intended. Yes, that's true. The video defendants now characterize as infringement used an album cover filter and audio. Defendants themselves created and distributed, used identically by more than 625,000 other fans. Yes. And that's my point. Like, are we all now guilty of, copyright, unauthorized use? Are we all about to be sued? Defendants cannot build a filter for fans, court its use, then call one fan's post misconduct when they get sued. Yeah. Defendants claim plaintiff never used the term life of a showgirl before their album. That is false. Plaintiff has used it for years, as defendants' own exhibits show. And then she points to her actual shows that she's done, and articles that she's written, and their actual titles. A Night in the Life of a Showgirl at Sea, which I have there. That's in Las Vegas Weekly in 2014. Then there's another one from 2015, The Secret Life of a Showgirl. And then another one in 2024, Maren Wade, the real, raw, and unglamorous side of the glamorous life of a showgirl. They likewise call plaintiff's podcast art a dramatic rebrand. It is not. Oof. Yeah, it is not. The green photography is from 2023 and appeared on materials promoting plaintiff's show in 2024, a year before the album. Okay, let's have a look at that one. These images are on their side. Actually, can I? Yeah, I can turn them. Great. Okay. There's one from November 2023. Here's another one. Again, also from November 2023. And then there's this little roll here. This is from 2024. You can see the green background is actually used quite a lot. And it is entirely unreasonable for Taylor Swift to try and claim authorship over that, and claim that this woman has used it as some kind of rebrand to align herself with Taylor Swift. Even defendant's own historical brand and exhibit shows the same color scheme: green, yellow, and pink. And this is what I said. I had an issue with this when we were looking, when Taylor Swift put in a before and after image of Maren Wade's kind of covers. I think they just leapt on the one on her book, but even that one had a splash of the green in the background. And I think I was sort of saying, like, well, no, all the elements are actually there. All the basic elements that are in, the before, that are in the after, they were actually in the before photo as well. Let's try and find actually that before and after then. Okay. Yeah, here it is. So this is from Taylor Swift's opposition, right? And she's saying, look at the album cover, look at what her Maren Wade's historical branding looked like, and here's the post brand, and it looks just like Taylor Swift's. Actually, No, when I did my video on this, I did say I think all the basic elements of the post announcement branding is actually in the historical branding. That green is there. Yes, it's in the background in a small little area, but it's there. And all she's done is rotate the colors themselves. So it looks like the colors are this person's brand. They formulate part of the brand in, the pink, the yellow, and the green. And they were all there in her post announcement branding. Okay. Right, let's continue. Defendants saw plaintiff's pre-existing visual identity and assumed it was derivative of theirs. That is reverse confusion. Wow, I love that. They've literally taken Taylor Swift's kind of response and gone, hold on a minute, you saw my branding and thought it was imitating yours? Well, that's my point. That's why we're here. That was it. That's incredible. That's an amazing um gotcha moment there. Love that. Okay. The unclean hands defense fails on every element. Unclean hands must be scrutinized with critical eye. Defendants must show four things by clear and convincing evidence. 1. Wrongful conduct undertaken with bad intent. 2. Bearing an immediate and unnecessary relation to the accrual of plaintiff's cause of action. 3. That has not ceased. And 4. That survives balancing against defendant's own misconduct and the public interest. Defendants establish none. No misconduct. Unclean hands requires wrongfulness, willfulness, bad faith, or gross negligence, proved by clear and convincing evidence. Defendants identify two categories of conduct: plaintiff's podcast photography and her social media posts. The first collapses on the documentary record. Plaintiff's photography and color scheme predate the album by 2 years. That leaves the videos through which plaintiff offered no goods, made no sales, and claimed no affiliation. She performed her decade-old comedic premise in the showgirl attire. The doctrine reaches conduct that affirmatively demonstrates consumer deception. It does not reach ordinary social media posts recast as misconduct after litigation begins. The intent element fails as well. The doctrine is unclean hands, not impure thoughts. Bad intent requires specific intent to deceive consumers about source. Even if plaintiff sought to engage with public interest surrounding the album, capitalizing on a market demand does not indicate an intent to confuse. Engaging with a cultural phenomenon is not deception. No nexus. Even assuming misconduct, it must bear an immediate and necessary relation to the accrual of plaintiff's cause of action. Had plaintiff never posted the podcast or a single video, the evidence supporting this motion would be identical. Plaintiff's claim derives from the similarity of the marks, which is what the USPTO evaluated to reach its refusal, not plaintiff's social media. Metro Publishing does not apply. The plaintiff there modified its mark to copy defendants, tainting the very rights it sought to enforce. Plaintiff's mark is unchanged. Conduct ceased. The defense also fails because the conduct ceased. A plaintiff's equity is judged by the facts existing as they were when suit was begun, not an earlier time. When conduct ends before litigation, unclean hands is precluded. Plaintiff's post stopped in October 2025, 5 months before suit. Balance favors plaintiff. Whatever survives must be balanced against defendants' own conduct and the public interest. On one side, podcast art using pre-existing photography and a few weeks of comedy videos voluntarily ceased with no documented harm. On the other, knowingly expanded exploitation of a designation the USPTO found confusingly similar and refused to register. When you put it like that, she makes a good argument. In Citizens Financial Group, plaintiffs' executives strategized to increase the consumer confusion on which the plaintiff's trademark claim rested. The Third Circuit reversed, finding the lower court had improperly weighted that conduct to the exclusion of the merits of plaintiff's claim and the public interest. If a campaign to manufacture confusion could not carry the defense there, ordinary social media posts cannot carry it here. The sleek craft factors favor plaintiff. Strength. Defendants do not contest their commercial strength. They document it. And they concede plaintiff's mark is suggestive, which, in a reverse confusion case against a commercially strong defendant, is dispositive. Indeed, plaintiff's mark is suggestive using defendant's dictionary. Confessions connotes guilt or sin, neither describes plaintiff's services. Defendant's crowded field argument fails. The analysis evaluates third-party trademark use, not bare registrations. Defendants offer registrations across unrelated categories and expressive work titles that, under their Rogers theory, are not trademarks at all. Neither shows actual trademark use in the relevant field. Similarity. Defendants build their argument on a side-by-side comparison. It is axiomatic in trademark law that side-by-side comparison is not the test. Defendants know it. UMG has told another court that side-by-side comparison is an incorrect test. True, because marks must be compared in the light of what occurs in the marketplace, not in the courtroom. These are not bottles of ketchup on a shelf. The marks live in Google suggestions, search results, and plain text. As UMG explained, differences are not present when the parties' marks appear in text on their websites, social media, or press coverage, because defendant's application covers standard characters, which are not limited to any particular rendition. Wonderful. The USPTO properly evaluated the marks as text and refused registration. Comparison of visual renditions makes sense only when the marks are consistently presented one way. The record here shows multiple variations of each. Defendant's argument that Swift's accompanying likeness dispels confusion is misplaced. First, the accompanying mark logic does not hold in text channels, Google autocomplete, social media text, which do not carry Swift's likeness. Second, the Ninth Circuit has rejected the theory that house marks cure confusion in reverse confusion cases. A junior user's fame is the engine of confusion, not the antidote. Defendants contend lead works dominate, but the confusion evidence shows the opposite. In every instance, consumers retained of a showgirl and swapped only the lead words. Defendants do the same. And then she cited they used the term official release party of a showgirl. Defendants claim a 6 and 7 syllable difference is meaningful, but the case they cite refutes them. Their sharp C argument makes no difference. Defendants only compare life to confessions, but must compare the marks in their entirety. Yeah. As wholes, both share an interview of the showgirl life, exactly how Swift describes the album. Proximity. This factor asks whether ordinary consumers would perceive a relationship between the goods. Consumer consumers expect brands to extend across categories. The licensing of musicians' marks into stage theatrical entertainment is familiar to consumers. Consumer care. This factor evaluates the reasonably prudent consumer, not a party's fans. Even so, defendants' own evidence cuts against them. It describes an eager fan base that analyzes clues, hints, and secret messages in everything. Consumers trained to hunt for connections everywhere are more likely to connect plaintiff's similarly named showgirl brand to defendants, not less. Channels and expansion. Defendant's only response regarding channels is that plaintiff has not recently posted on her website. That is not the test. Plaintiff's brand is also expanding. A new edition of her book and more podcast episodes are planned. Live shows are paused due to personal safety concerns. And we do actually have an example of that in action. We'll go to TV and Movie Addicts X account. I'm not sure if this is the same lawsuit that the Swiftie account is talking about, but this was posted just a few days ago. Yeah, 2 days ago. From Taylor Swift Updates. And it's a fan account in capital letters. Swifties, let's write a letter. Olivia needs to debunk that fake lawsuit because it has done irreversible damage on Taylor's image, even if we all know it's simply not true. She can't be seen her entire career as Taylor's victim. It's time for her to do something real for her career and legacy, and her team needs to be changed immediately. Since she's announced the album, they have only been crashing their cars. If any of you makes one post in the comments, and let's choose the best one and post it everywhere. We need to grind. And then someone says the concept of this being a real tweet. But then TV and Movie Addict then says they mean business when writing this in all capital letters. But Swifties are known for being particularly aggressive when they, when they kind of hunt down, anyone. Like when I was covering, I didn't get it so much actually. I was incredibly lucky. But I know that Ashley, Brianna, Eve, and CJ, when they were covering anything to do with Taylor Swift in particular, if anyone said anything, anything that referred to Taylor Swift in the Blake Lively case, so any mention of text messages and so on and so forth, I know that those two in particular were quite viciously set upon by Swifties. It was really quite brutal to see. And I know that they're not the only ones. Many content creators, kind of experience quite extreme, unhinged attacks. Just completely unnecessary. And again, like I say, so far I have been very fortunate, and I have not had that. But I mean, I don't really kind of take an opinion too much. I don't lean too hard for or against anyone. So yeah, I can see the concern over safety, when you file an entire lawsuit against Taylor Swift. So now we have actual confusion. When UMG was the plaintiff, it told the court that actual confusion need not be shown, and when such proof exists, very little proof of actual confusion is necessary. It also asserted that a demand for survey evidence at the preliminary injunction stage fails. Defendants take the opposite position here. The law has not changed, only defendant's side of the caption has. Intent. Defendants argue plaintiff has not shown their intent to associate with her brand. That is the wrong test. Reverse confusion intent is established where the defendant culpably disregarded the risk of reverse confusion. Their argument is that their use is objectively fair, cannot survive the USPTO refusal. Ugh. And then they quote UMG again, defendant proceeds in full speed ahead despite notice of infringement is evidence of bad faith. UMG are getting an absolute roasting in this. All doubts are resolved in favour of the senior user. Defendant's irreparable harm arguments fail. Delay. Delay rebuts the harm presumption only where it is unexplained. The timeline is explained. Plaintiff consulted counsel when defendants announced the album in 2025, but believed at the time that an album title alone was beyond trademark law's reach. As defendants emphasized, the USPTO's November 5th refusal was non-final and the issues potentially curable. A reasonable person could expect defendants to attempt to cure, but they did not. On March 3rd, 2026, defendants suspended their application and continued using the refused designation. The case crystallized then. Plaintiff retained counsel and filed suit that same month. Defendant's position that plaintiff should have sued in August is irreconcilable. Defendant's position that plaintiff should have sued in August is irreconcilable with their Rogers argument. A claim ripens not on first awareness of a mark, but when it becomes actionable and provable. Otherwise, mark owners would be hoisted upon the horns of an inequitable dilemma: sue immediately and lose, or wait and be dismissed for unreasonable delay. The defense is also available only to a party acting in good faith. Continued mark use after registration refusal is not good faith. Compensability. Reverse confusion is not about lost revenue, it is about erasure. The senior user's mark is displaced by the junior user's market saturation until the senior user's brand is irreversibly subordinate. Defendants characterize the search result evidence as consumer preference, not consumer confusion. The distinction collapses in a reverse confusion case. When the marks are similar enough to compete for space, for example on Google, consumer engagement at defendant scale does not coexist with the senior user's mark. It overwrites it. Erasure is not an economic harm. Damages cannot fix it. And I like that argument actually, because I am really kind of over this belief by, people who have copious amounts of money that money will fix everything and you can just throw money at a problem and be made whole again, and that is not always the case. And quite rightly so, that's not the case here. When someone has spent 10 years of their life working with a brand that Taylor Swift has already managed to, largely monopolize within a very short period of time, like literally a few months. Quality issues compound the injury. That harm is acute where the infringing product is of poor quality or simply not worth the price. Consumers rate the album 3.7 out of 10. Now they're bashing Taylor Swift's album. The merchandise draws repeated quality complaints. Plaintiff cannot correct these issues, but through mark similarity is tied to them. Oh, it's just saying, oh, well, people think Taylor Swift's album is shit. There's, repeated quality complaints from, about the merchandise. Nothing I can do about that. But unfortunately, I'm tied to your bad reviews. Oh, this is quite a roast. To be fair, this is such a good drafting. I'm almost hitting fangirl status now. The balance of hardships favors plaintiff. Defendants frame the injunction as disrupting the status quo. It is not. The relevant status quo is the last uncontested status which preceded the pending controversy. Before the album. Defendants also invoke catastrophic consequences unmoored from the actual scope of relief. Defendants' merchandise is sold exclusively through their own website, making compliance largely a single channel adjustment. The injunction merely pauses the use of the mark. It does not require inventory destruction. It does not reach Swift's broader catalogue or career. The 11 album tracks not titled with the contested designation or any planned tour. There is none. Defendants' concerns are overstated. And then they quote UMG again: defendant would not be substantially harmed. It would simply have to change the name under which it offers services. Relative size of the respective business is relevant to the potential hardship. Crediting defendant's projected loss, that figure is 0.1% of UMG's 2025 revenue alone. Plaintiff, however, faces erasure of the only brand she has. Yeah, that's absolutely fair. Public interest favours relief. Bond should be waived. Defendants' public interest and bond arguments share the same defect. Both treat commercial scale as a reason against trademark remedies, and both would render reverse confusion nugatory. If wide popularity defeated the public interest in injunctive relief, every successful infringer would be immune. Further, the Ninth Circuit holds courts may order nominal bond or none at all. A bond set to defendant's scale would exceed plaintiff's means by orders of magnitude, deny the relief Congress restored, and nullify application of reverse confusion. The Lanham Act would protect similar plaintiffs on paper but price them out of court. That cannot be the law. And then the conclusion: the motion should be granted. Preliminary injunction should issue. That was that was really good. I enjoyed that. And I do like the fact that, I mean, the complaint and the motion for preliminary injunction was incredibly fair and measured, and it went through point by point all the very sound reasons for Maren Wade bringing the action and then requesting the temporary injunction. The response was, like, as I said at the start, it was overly aggressive. Now, lawyers will aggressively advocate for their clients, and even more so when it's someone like Taylor Swift. I understand that. No problem with that. But it seems so unnecessarily personal to be just kind of disrespectful about, you know, Maren Wade's career. It's like, well, she's just, a girl who prances around on a stage at golf clubs. And like Taylor Swift is, this global superstar who's done, all this and this and this. And it's like you're comparing apples and oranges. At the end of the day, you know, Maren Wade has done her career. What she's done with it, what she wants to do, she is quite happy, and she is trying to protect the brand. At the end, that's as simple as that, right? And Taylor Swift's response did seem to be drafted, just to be kind of, looking down her nose almost at her. But this response really holds its own. It gives back every bit as good as it got, like by pointing out how poorly rated Taylor Swift's album is, how all the complaints with the merchandise and so on and so forth. And then the hypocrisy as well. I love the hypocrisy. And just basically throwing UMG's own words from a previous lawsuit and using them against themselves, because obviously they are also dependents in this. Really well done. I'm kind of excited actually about this now. I feel like this is going to be a bit of a spicy lawsuit. So I'm glad I've come into it now. Um, yeah, I hope you enjoyed it as much as I did. I do have Maren Wade's declaration, so I wanted to go through that just quickly. It's only one page. But this is the declaration of Marine Flag in support of her motion for a preliminary injunction. I, Marine Flag, declare as follows. I am the plaintiff in this action. I submit this declaration in connection with the reply in support of plaintiff's motion for a preliminary injunction. Except where otherwise stated, I have personal knowledge of the facts set forth herein, and, if called as a witness, could and would so testify. And I think she's just addressing some points here, like, well, you haven't done this for a long time, and you haven't done that, and you've not got any books for sale, blah blah blah. So that's what this says. And she says, I'm planning to release a new edition of my book, and I plan to publish additional episodes of my podcast. As of the date of this declaration, I have paused scheduling of live Confessions of a Showgirl performances due to personal safety concerns that have arisen during the pendency of this action. And I could very well believe that this poor woman is suffering death threats and abuse of all kinds from unhinged Swifties. Because I've seen it. I haven't experienced it, but I have seen it. And it's just absolutely wild. When I learned in August 2025 that Taylor Swift's new album was titled The Life of a Showgirl, I consulted with counsel. At that time, I did not believe I had a trademark claim against the use of an album title alone. Attached here to as Exhibit 42 is a true and correct screen recording captured by me on May the 11th, 2026 of a video I posted on Instagram on September 11th, 2024, promoting my upcoming live performance of Confessions of a Showgirl. This exhibit is being lodged separately with the court. It's so at the moment it is just a USB device, so there is nothing there that I can bring up to show. But yeah. Yeah, and I declare under penalty of perjury that the foregoing is true and correct. So there we go. That is the reply, and we've looked at some of the exhibits as well. I think it was a very good response. I would love to know what you all think in the comments, as always, but I hope you enjoyed it.